So guilty across the board on all 7 counts for the former Assembly Speaker, but a lot of questions obviously still remain. Could Silver still possibly give up information on other people in Albany? A lot of people thought that was certainly going to be one of the things we'd hear at this trial. Also, what could be next for one Preet Bharara, the U.S. attorney who made this basically his case here, and where could this go as it relates to even the governor? Okay, for all of that, let's bring in a couple of our favorite panelists. Jeanne Zaino, professor of political science at Iona College and also professor of campaign management at NYU, and Bill Aronwald. Bill's a defense attorney and former assistant U.S. attorney. All right, let's get into legal stuff first, and then we'll get into some of the political stuff. But we were talking right before we came back from break. No defense put up by the Silver team. We understand, and we don't know the details of it, but that the prosecution offered the Silver team a plea deal, of which the defense team refused. First off, if they didn't put on a defense and they didn't take a plea deal, they obviously thought they were going to get a different verdict than the one they got yesterday. So my question to you, Bill, is, did they completely read the tea leaves wrong, or they didn't have a card to play?
Well, you know, there are 2 forms of defense. I mean, I'm sure that his lawyers felt they did put forth a defense through their cross-examination of the government's witnesses, and, you know, and from the lack of certain evidence, that's what they would have argued to the jury. I mean, the most powerful witnesses for the defense here were the doctor, and the 2 real estate lawyers, real estate people. So, you know, from that standpoint, I mean, I think they felt they put forth as best the defense they could. The only other thing they could have done would have put Silver on the stand himself.
Well, there was one other thing, Bill, which is they made 2 arguments to the defense at the beginning. One is that there was no quid pro quo. That forget what Dr. Taub believed and forget what the guys at Glenwood had to say. They never, and they testified to as much, there was never a stated deal, I'll give you this if you give me that. The other thing was all the other kids did it, which was, you may not like what my client had to do, Mr. Silver, but all of them were doing. In fact, this was the original potential witness list that never got called here. You can see some names you all recognize. One guy across the plaza right now is on trial himself, Dean Skelos, the former Senate Majority Leader, the governor, of course. Then Jonathan Lippman, the Chief Justice, Assemblyman Keith Wright. You have Vito Lopez, who died right before the trial began, but he had his own troubles, and the Rap Vogels, and that in itself could have been another, made-for-TV movie with some of the allegations going around, the relationships between the speaker and those 2. Nonetheless, he could have muddied the waters a little bit to the point where it said, my God, the whole place stinks. He's just one fish here in a really dirty pond. They didn't play that card.
Yeah, and that's a tough argument to make, because what you're really saying is, look, my client may be dirty, but look, everybody around him is dirty, so, you know, if they're not, why should he be singled out for this treatment? I mean, that's really not an argument that's going to play well with the jury. You know, the biggest problem here is that the public perception is such that the public is not shocked when they hear that a well-respected, highly regarded public official is accused of corruption. You know, the public mindset is that the public distrusts their elected officials. And so my position is that when you're representing a public official, the cards are stacked against you. I'm not sure you can get a fair jury, because the jury comes in with this preconceived perception that all politicians are crooks. So what you hope for is you hope that you have a really good judge, a judge who's intellectually honest, good reputation, not favoring one side or the other, and then you have to make the hard decision. And that decision is, do you give up your right to a jury and go non-jury? Now, of course, federally, the government has to agree with that. But I can't imagine that the government would say no to a non-jury trial, because the government's position is, you know, our cards are so well stacked that we're going to win no matter with what. But that's really the problem.
Okay, so the argument from the Silver team, we heard Mr. Molo's lead counsel say, we're going for a retrial here, we're appealing the verdict in effect. It seems, you help me out here, his 2 biggest principles arguments are going to be, you heard from the juror that we played for at the beginning that she was conflicted and she felt pressured by the other jurors here. We haven't heard juror misconduct and everything, but nonetheless there was that. Plus, there was people who were complaining about potential conflicts of interest, none that would really, I think, help the defense, but nonetheless that came up. The second part is, did the judge instruct the jury the right way as to what threshold had to be proven for a conviction? Do you think either of those, what went on in the jury deliberations, and 2, how the jury was charged, do they have an argument on either front?
The issue with respect to the juror who sent out a note 2 hours after they got the case that she was being harassed, she wasn't feeling well, she wanted to be excused, that argument's not going to get them anywhere. The fact is the judge gave an instruction to the jury telling them that their obligation was to reason together, talk together, collectively think together. And at the end of the day, even when interviewed, the jury basically explained that she was convinced by the evidence, not because of any additional pressure.
Yeah.
She also said that she wasn't being pressured by everybody, just by a few people. With respect to the other one about the conflict, I think the judge handled that one correctly too. It really wasn't a conflict. But with respect to the judge's instructions, I've read the instructions. I think the instructions will withstand appellate scrutiny. I think the one issue in the case, though, goes back to before the trial. And that was the defense moved to dismiss the indictment for prejudicial statements made by Preet Bharara when he announced the indictment, which went way beyond the pale, exceeded the four corners of the indictment, which is what their press comments are supposed to be restricted to. Judge Caproni agreed that Preet's comments went way beyond the pale. They went overboard. However, she decided that she was going to deny the motion, and she said that she thought that the defendant could still get a fair trial. I think that's an interesting issue because I think appellate courts have never really gotten their arms around the argument that a defendant's rights to a fair trial can be irrevocably prejudiced by unfair extrajudicial comments made by prosecutors when they announce indictments. That's an issue which I think the defense is sure to raise. As far as the judge's instructions, they may raise it, but I think that the judge's instructions were on balance proper.
We'll get into the political implications, Jeannie, in a little bit, but on the legal side, I thought the Shelley Silver that I've known, right, and covered for 2 more years than I want to admit, he would have thrown the kitchen sink at this thing. Just because if I'm going down, I'm taking down people with us. We didn't see that. Now, we'll talk with Bill in a second. Between now and sentencing, there's still more cards theoretically that can be played. But it doesn't fit his MO, which is he knew where everybody was buried in Albany. If he wanted to, he had other cards, another, things to trade here. He didn't choose to do it.
Yeah, and I think that's what's so shocking. Obviously, Bill knows better the legal perspective, but just looking at it from an outsider political perspective, this is not the Shelley Silver we knew. It seemed like they didn't fight. It seemed like they could have made the case that there was very little evidence of a quid pro quo. And as you mentioned, he also had the whole angle of all the bodies he knows that are buried, which are numerous. And yet none of them came out, which I kept thinking, they've got to have an inside track. They've got to imagine that he's going to skate clear of these charges and that he's not going to have to, face the music. And then to hear, I have to say I was stunned to hear he was found guilty on all 6 charges, just because of the fact that you mentioned he didn't seem to fight the charges in a Shelley Silver style.
No, it's not. So, Bill, you've been on both sides of this, as you mentioned, a former prosecutor with the U.S. Attorney's Office and a defense attorney. You get the verdict you don't want, you get back. First off, what could he be looking at in terms of a sentence, and what kind of guidelines typically are followed in this? And then secondly, if you do have other cards to play, other than what you already mentioned to try and get a retrial here, what would you go to the prosecution and say potentially, assuming you do, you could trade, and what would you be looking for?
Well, as far as the sentencing issue is concerned, when Congress passes a statute making something a crime, Congress makes the determinations what the maximum penalty is. So in this case, there's been a lot of speculation. He faces 130 years. Well, yeah, he faces 130 years if he got the maximum on each count and was sentenced consecutively on each count. That will not happen. Aside from his age, it never happened, so it's not going to happen here. There are federal sentencing guidelines, which used to be mandatory but are no longer mandatory. So judges are required to consult the guidelines. The guidelines are supposed to inform a judge's decision as to what the sentence should be. But judges also can consider other factors, what his background is, his public service, the things he did positively when he was, in the state's legislature, and so on and so forth. I've looked at the guidelines, and the guideline range here, without looking, basically, is about 19 and a half to 24 and a half years. If the judge decided that she was going to follow the guidelines and impose a sentence within the guidelines, that's what the sentence would be, anywhere from 19 and a half to 24 and a half years. I think that's unlikely also. But the fact is, you take a look at the sentences that have been meted out to other public officials. Judges are now sentencing public officials to a substantial amount of prison time. And
so in the effect, since he's over 70, Bill, right? if he gets a 20-year sentence, it's
It
for
could
all
be a
intents
life-
and purposes, it's a life sentence.
Now, as to the cooperation
Yeah.
point of view, it's never too late to cooperate. The government always has its hand out. The government's always willing to take cooperation. But the fact of the matter is the only benefit that he would get from the cooperation is leniency on sentencing. But you're 71 years of age. The likelihood of your cooperation resulting in a probationary, non-incarceratory sentence is virtually nil. So he has to be reconciled and resigned to the fact that even with cooperation, he probably will go to jail. The question
But there's
is
a
to how long.
difference as to also where
Well,
he's
you-
going to jail too, right?
Well, the Bureau
Wouldn't you
of
rather go
Prisons,
to a country club than you would a...
well, the Bureau of Prisons, not the court, makes a determination as to what prison you go to. The judge can make a recommendation, but the Bureau of Prisons can be very prickly and very sensitive to the fact that judges may be interfering with their decision as to where the placement should be. No question about it. I mean, he's 71 years old. He's not a violent criminal. Regardless of what the sentence is, he's not going to go to a maximum security place or even a medium security place. But the bottom line is you're 71 years of age.
Yeah.
So does it really make a difference whether you get a 5 or a 6 year sentence or you get a 10-year sentence? However, you're also presupposing that he has information that the
Right.
government
And
would
we don't
find
know that.
valuable. We don't know that.
Yep.
And the government doesn't often like to trade down, they like to trade up.
Okay. When we come back, there's still a couple players here, leaving aside the Skelos trial for the moment, and certainly I don't think the Silver trial helped him out in any way, shape, or form, especially with the wiretaps Dominic just played. But nonetheless, what about the third guy in the room? And that would be Governor Cuomo. What about Preet Bharara and maybe some of his future plans here going forward? And what about Albany as a whole? Did things really change coming out of this? And what could change look like? I'll ask our panel about that and more after this.